Okay, good morning again, everyone. I'm back. So I am chairing the first session, which is Governing Hate Online, Law, Responsibility, and Platform Power. And this session examines how hate speech is managed online, from legal frameworks and platform responsibilities to real-world challenges, highlighting the tension between free expression and protection from harm. So our fourth speaker unfortunately isn't able to join us. So I'm using my authority to allow a little bit extra time to our speakers, and then we'll open it up for Q&A. So our first speaker is Professor Gavin Phillipson from the University of Bristol, talking about harmful online speech, 5 models of platform regulation. You have a little over 15 minutes.
Thank you very much, Eliza, and I'm delighted to be here. Do I have my slides? Yes, they're there. Excellent. So my name is Gavin Phillipson. I'm presenting this on behalf of myself and my co-author, Robert Simpson, who's from the Philosophy Department at University College London. And the paper is forthcoming in the Oxford Handbook on Hate Speech, which we published sometime in 2026. So the purpose of this paper, as the title indicates, is to set out and evaluate what we argue are 5 broad models for regulating, or indeed leaving to self-regulation, the content moderation practices of extreme speech by platforms, including, of course, hate speech. 2 of these are drawn from the United States and 3 from the European Union. And the paper evaluates each model in a particular way, not in terms of which is most likely to be effective in combating hate speech, but rather how far each is a legitimate approach for a democratic state to exercise or decline to exercise governmental power in this area. In referring to content moderation, that has several forms, as I'm sure you know. The sharp end is content removal. The softer version is what is known as demotion, the rendering of certain kinds of posts as less visible, less likely to be seen, at the extreme end of which is the practice known as shadow banning. So I think in order to have a meaningful debate about this topic, we have to note one basic fact at the outset, that the removal from social media platforms of various kinds of objectionable speech is going on all the time at absolutely enormous scale, regardless of what role the state has. So the question this paper asks is not whether this vast scale of content removal and demotion is a good or a bad thing in terms of free speech, but rather it addresses a more specific issue of what is the appropriate role for the state in this process. So I think to answer that question, you first of all have to go back a stage and ask something more basic. What kind of interference in free speech is involved in having your posts, or in more serious cases, yourself, your account, removed from one or more social media platforms? And here there are 2 opposing, and I would say rather simplistic answers, both of which I think we should avoid. So, yes, there we are. So, the first is the traditional liberal view, still represented by US constitutional law in terms of the First Amendment, which says that concerns about the content moderation policies of big tech have nothing to do with the right to free speech, because only the state is obliged to respect that right. Whereas these are just private platforms who, just as you and I would be if we had our own personal website, are perfectly entitled to decide what kind of content they do and don't host as an aspect of their market freedom, or indeed as an aspect of their expressive rights, as the US Supreme Court sees it. And a recent monograph on free speech theory by Professor Paul Ragg in the UK, published recently, argues precisely that point of view. This is not a free speech issue. The second, sorry, I'll come to that in a moment. The second simplistic view is one that shouts censorship every time someone or their post is removed from a given platform. And the risk in that point of view is to collapse the obvious and important distinction between things that only the state can do, subject you to criminal sanctions for what you say, silence you through injunctions, bankrupt you with huge fines, and those that private bodies can do, which is only deny you or your post a particular platform. So we have to recognise that coercive state intervention differs qualitatively from measures that private platforms can take in crucial ways. But equally, the first of these views, the state-centric one, is no longer, I think, sustainable, either in principle or in light of actual multiple legal developments in this area. So these include the decision of the German Constitutional Court in the Facebook case, in which the court ordered Facebook to restore a post by a right-wing anti-immigration party it had removed during the election campaign because it was seen as being crucial core political speech, and a 2022 decision of the Superior Court of Ontario in a case called Cool World and Twitter to allow a claim of breach of contract to proceed against Twitter for deleting the trailer for a left-wing documentary. The argument was that contract terms, such as those stating Twitter's policies, its community standards, and its absolute discretion that it claims to remove content, should not be enforced where that freedom of contract is outweighed by applicable public policy, in this case, freedom of expression as protected by the Canadian Charter of Rights and Freedoms. So a classic example of what we in Europe would term indirect horizontal effect. So I think instead of either of those two simplistic views, we need a more nuanced one. Having your speech removed from social media platforms may be seen as a setback to your expressive interests, but it is of a different order to criminal punishment or prior restraint. In particular, the aim is different. Neither silencing your speech completely, for you can still utter it in other more traditional forums, nor punishment, because you are not fined or imprisoned, but rather what we could term influence reduction. The aim seems to be to lower the visibility, reach, and hence the capacity for harmful influence of certain classes of speech. So I think rather than thinking about the harm, what we should do is think about the harm to speech interest that occurs via content moderation on a sliding scale, whereby the adverse impact on the reach and influence of your speech can be more or less depending on a number of contextual elements. So these include, obviously, the scale of deplatforming. Are you removed? Is your post being removed from only one platform or from multiple platforms, perhaps across all the major platforms? Something more likely to happen, of course, if a public body is coordinating that removal effort. Second, what other channels does the speaker have for getting their speech into the public domain? At the extreme end of the spectrum, someone like President Trump obviously was relatively unaffected by having his account removed from Twitter and Facebook in the aftermath of the Capitol riots. Other people may, however, find that their ability to reach the public is more or less removed if they or their account is removed from social media platforms. And I think finally, when we think about this, free speech law and theory often looks at either or both of the speaker's interest in being able to speak freely and the audience interest. I think the audience interest is particularly important in the context of content moderation and the instrumental arguments that if you value free speech primarily for its role in creating a rich discursive environment for audiences, for democratic participation, for democratic debate, and of course knowledge generation, then you will be concerned, or you may have a legitimate concern, in how and why content is removed or demoted from social media platforms. And you may think that the state has some kind of legitimate role in intervening to do something about the way in which that happens, as of course it has been doing. So having kind of cleared the ground with that initial consideration of what kind of free speech interests are at stake, I want to move on to consider the 5 models we propose as a means of classifying the options that we have seen are kind of out there for the regulation or the self-regulation of content moderation. And that's how we break them down in the paper. So the first of these we term pure self-regulation, which is still the operative model in the United States, governed by the First Amendment and what's called the Communications Decency Act, Section 230, CDA 230. And the US position, although we may not approve of it, or although Europe has diverged sharply from it, is still of great importance because, of course, most of the major social media platforms are American-owned, and they are very much imbibed with the culture of the First Amendment in US attitudes towards free speech. And we see this in the current tensions between the US and Europe over this matter, amongst others. What do we mean by pure self-regulation? Simply that while, of course, there can still be forms of voluntary collaboration between platforms and between platforms, governments, and international bodies like, for example, the WHO, there is neither a formal role for the state, nor can there be an informal but coercive government role in prescribing content moderation standards, processes, or outcomes. The result is that the main guardrails on public discourse are devised and implemented by the content moderation policy practices of private corporations. So the legal elements are the First Amendment's stance that speakers on social media platforms have no constitutional right to free speech because that only runs against the state, but actually the corporations themselves do have First Amendment rights to curate content as they see fit. The analogy is as if they were the editors of a newspaper, and the way they choose to curate content is an aspect of their expressive rights. So what might look like a very American outcome, the individuals have no rights, but the corporations have all the rights. As someone said, the platforms have their own free speech rights and everyone else's too. And that is supplemented by Communications Decency Act, Section 230, CDA 230, sometimes compared to the long-standing principle of conditional immunity in EU law under first the E-Commerce Directive and now, of course, the Digital Services Act, but I think sharply different. The difference being that under the EU standard, platforms cannot be liable for hosting illegal content until they are notified and then fail to promptly remove it. Whereas in the US, subject to the exceptions in CDA 230, even when platforms know they are hosting illegal content, have perhaps lovingly selected it as illegal content, as in the case of notorious revenge pornography sites, they still can have no liability for that content itself. And of course, many of the people who are posting it are anonymous, and legal action against them is not possible. Fortunately, in relation to revenge porn, Congress recently passed the Take It Down Act, which does aim to tackle deepfake pornography and revenge porn, and both make it a crime and to require social media platforms to take you down on notice. Of course, that may be subject to First Amendment challenge. Our case against this model is simple, that the formulation and operation of content moderation standards, standards of transparency, the provision of due process rights to speakers, are simply of too much significance for public discourse for their governance to be left wholly in the hands of private corporations. If the First Amendment requires this outcome constitutionally, I think the European perspective is the opposite, that a purely private ordering of the online public sphere is democratically unacceptable. Or to put it more bluntly in this field, from the European perspective, pure self-regulation means democratic deficit. So what are the options if the state wants to get in on the regulatory interventions into this scheme? And we will see that the things we look at have a number of these ingredients. So we have legally binding notice and takedown powers, procedural interventions, which are aiming to provide greater platform transparency and to endow speakers with a range of due process rights, in particular the ability to swiftly contest removal decisions and get their speech restored if wrongly removed. What are called user empowerment tools to give adults the ability to choose certain kinds of content that they don't wish to encounter. And then, of course, a particular focus of the UK's recent Online Safety Act, restricting the access of minors to certain categories of lawful but harmful content. Particular feature of the Digital Services Act, soft risk mitigation duties, requiring platforms to formulate, consult with society groups their own plans for dealing with lawful speech that can pose a range of systemic risks to society, particularly in the areas of public health or fair elections. And then, of course, large fines for non-compliance. That's the kind of menu of options that we see for state intervention. So what's Model B? Well, Model B, I argue that we see both in an informal way in the US and in a more formal way in the EU. In the US, this is known as jawboning. So informal government pressure sometimes happening behind the scenes. And controversy arose particularly in the US in relation to informal pressure on platforms to remove certain kinds of mis and disinformation during the COVID pandemic. Now, given platform power, it's of course completely understandable why well-intentioned governments may want to at least advise that moderation policies are exercised in ways that promote the public good rather than just corporate economic self-interest. But we think there's two problems here. First of all, precisely because these are just informal practices. There are no built-in formal mechanisms for either transparency or accountability. The media might find out what's going on, as in the recent First Amendment challenge to negotiations between the Biden administration and the platforms during the pandemic, revealed in the so-called Twitter files, but they may not. A more recent example that you may have, that was covered quite a lot here, was, in the UK anyway, was the attempt to jawbone a media company from removing the Jimmy Kimmel Show, a popular late-night show from the US, through not very subtle pressure from the head of the Federal Communications Commission. We can do this the hard way or the easy way. The show was actually restored, perhaps because it was such an obviously unlawful attempt to pressurize through informal means a private company from putting on a particular show by an aspect of the government. And this is the other thing that I'd highlight as something that happened at the beginning of this year. Not so much perhaps pressure on platforms, but just the cozying up of platforms to the Trump administration at the beginning of the Trump second term, where very overtly both X, which of course owned by Elon Musk, who actually worked within the US government for a period, but also Mark Zuckerberg making announcements about the Meta platforms that were seeking to directly align themselves more closely with what they saw as the administration's values and its approach to free speech, and hoping to get, as they very clearly said, the US government on side in their attempt to fight regulation primarily from the European Union that was affecting their freedom to content moderate as they saw fit. Jawboning can violate the First Amendment. Unfortunately, the case law is not very clear, and the US Supreme Court declined to decide substantively a challenge brought against the Biden administration in relation to COVID misinformation that I mentioned, where the Supreme Court decided that the claimants didn't have standing and therefore didn't give a substantive decision. So the law remains not very clear there. Yeah. Model C. This is remaining within the voluntary sphere. You will be familiar with this probably. Non-legal and ostensibly voluntary arrangements between the EU Commission and major social media platforms. Under the hate speech code, this was actually quite a potent, non-informal power, whereby platforms agreed to comply rapidly, normally within 24 hours, with notice and takedown orders in relation to hate speech identified by public authorities and trusted flaggers. It had one advantage from how it goes on in the US. It was publicly announced, the Commission kept records and documentation, the code itself was actually published, so the whole thing did have some degree of transparency, but there was no formal legal regime. And our argument on that one is that in such schemes, governments are attempting to get the benefit of influence over platform policy without accepting what should be the correlative burden, framing proposals for legislative deliberation, public debate, and ultimately constitutional scrutiny in the courts. I have my little 3 extra minutes, do I not?
I'm giving them to you. You're almost up.
I'm nearly done. Finally, the fact that these schemes give public authorities quite considerable de facto power over content moderation decisions is not balanced, as with legislated models, with the provision of any due process rights for speakers or enhanced accountability duties for platforms. So what are the legislative schemes? 2 minutes. No. 2 minutes. Eliza.
Sorry,
I'll be very quick.
This is my PhD supervisor, by the way, so we know each other very well.
I'll be very quick.
You get 1 minute.
Yes, okay. Some of you may be familiar with this. This relates to terrorism-related content, where the essence of the scheme is to empower a range of public authorities to require the immediate removal within 1 hour of specified items of content that fall within a very broadly defined class of illegal content, in this case, terrorism-related material. It does have, obviously, democratic legitimacy, it does have transparency, and it does have remedies, which are all good things. Look how fast I'm going, Eliza. But the draconian notice and takedown powers, which preclude any possibility of serious deliberation over whether this actually should be considered as protected political speech or not, means that the combination of that with the very broad, ill-defined general category of terrorism-related content, which lumps together bomb-making instructions, as Eliza and I have argued in an excellent chapter, together with incitements to violence, but the more general and diffuse notion of glorification of terrorism, I am wrapping it up indeed, means that we regard this as being wide open to authoritarian abuse. Okay. And then finally, 1 minute, Eliza. What we think is the best available scheme, which happens to happily coincide with the EU's Digital Services Act, and others as well, the UK's Online Safety Act is broadly in the same category, and Germany's Next DG law. The key distinction between this and TERIG is that rather than the state seeking to direct content moderation outcomes, in other words, get content removed, it instead deals with it only applies to already illegal speech, and it seeks to ensure that that speech, the way in which platforms deal with that speech, is A, as transparent as possible, B, as wide open to challenge in the courts because it's a fully legislated public law and therefore open to both constitutional and legal challenge, and also that there are strong due process rights for speakers. So that's why we defend that as the best available model out there, if not optimum. And I'm done. Thank you.
Thank you, Gavin. You guys get more time as a result of that, don't worry. So it should be equal. Okay, so our next speaker is Lavinia Pedol.
Good morning, everyone. I'm Lavinia Pedol, and I'm a PhD candidate at University of Milano. It's a pleasure to be here today, and I'd like to thank the organizer for bringing us together and providing such an important space for conversation. Today, I'll be discussing an issue that in recent years has become central to legal, political, and social debate: the evolution of online hate speech and the attempts to regulate it within the European framework. We live in a time in which digital platforms have profoundly reshaped our communicative spaces. The speed at which content is produced, shared, and disseminated has expanded opportunities for expression, but it has also intensified hostility, discrimination, and verbal violence. In this context, defining a legally sound and operationally workable notion of hate speech is extremely challenging because it sits at the crossroad of regulatory, technological, and social cultural dimension. Few concepts in contemporary public disclosure are as contested as hate speech. There is no single accepted definition. Some scholars identified it with offensive or abusive language, others limited to speech that explicitly promotes hatred or incites violence. Importantly, hate speech is not limited to words. It may take symbolic, visual, or mimetic form, and it's spread across traditional media and increasingly nowadays with social media like Facebook, Instagram, TikTok, YouTube. Online hate is more dangerous because it acquires specific characteristics: persistent over time, unlimited replicability, anonymity, and transnational dissemination. These characteristics make digital hate more pervasive and more difficult to tackle with traditional legal tools. Online hatred is no longer a marginal phenomenon. It has become a structural component of the digital environment. It no longer lives only on extremist forums. It permeates mainstream platforms, comment section, and everyday online dialogue. Social media, initially designed as a tool of connection and democratic participation, also act now as powerful amplifiers of hostility. Their algorithms privilege emotionally charged content like indignation, anger, fear, and hate. This dynamic fuels polarization and radicalization, encouraging users to remain in echo chambers where intolerance is reinforced rather than challenged. Hate speech targets vulnerable groups more than others, like women, ethnic and religious minorities, LGBTQIA+ communities, and persons with disabilities. Online hatred performs a symbolic social function. It draws boundaries between us and them, reinforces stereotypes, and legitimizes exclusion. Recent global crises like migration, terrorism, political polarization, and COVID pandemic have intensified these dynamics, unfortunately. At the same time, we cannot underestimate the real-world consequences of online hate, because online hate is not limited to the virtual world. The tragic events of Halle and Christchurch and all the discrimination that people suffer every day on the streets remind us that digital radicalization can fuel offline violence, and we must be able to prevent these tragic events. Over the years, the EU has developed a strategy combining soft law initiative, co-regulatory mechanism, and eventually binding regulation. A key starting point was the e-commerce directive in 2000, which introduced the safe harbor regime, no general monitoring obligation for intermediaries, and no liability unless they obtain actual knowledge of illegal content. From 2016, the European Commission intensified its efforts. However, voluntary commitment proved insufficient. This led the adoption of the Digital Services Act in 2024, a true turning point. The DSA introduced obligation of due diligence, transparency, and accountability for all intermediary service providers, especially the very large online platforms like Facebook, TikTok, Instagram. Among its key innovations, the DSA provides for accessible notice and action mechanism, detailed obligation of transparency and reason giving for content removals, internal compliance system, trusted flagger with priority reporting rights, and systematic risk assessment and mitigation duties for the very large online platform. In many ways, the DSA signals the EU aspiration to construct a safe, predictable, and rights-based digital environment, often described as digital constitution for Europe. Although the DSA is new and innovative, and we are awaiting the real consequence of its implementation, but the DSA brings challenges that could make its application irregular, especially for three reasons. First, the DSA definition of illegal content in Article 3 is deliberately broad. While this allows flexibility across different national laws, it also risks inconsistent application and excessive discretion by platform, especially in borderline cases. So we need to find a new definition of illegal content unified for all the states. Secondly, identifying the authors of online hate speech remains extremely difficult. Platforms often hesitate to share identifying data. Meanwhile, pseudonymous, fake accounts, VPNs, and anonymization tools make traceability increasingly complex. Third, the growing privatization of content moderation. The problem is that delegating to private digital platform the power to decide what is removed and what remains online may lead to discretionary enforcement, and the absence of judicial oversight make a chilling effect. So the user freedom of expression is a problem because the user don't want to spread the information. So for the chilling effect, they don't publish. The challenge for the DSA is therefore to protect democratic pluralism while safeguarding collective security. To achieve this balance, platforms must invest not only in more accurate AI-based detection system, but also in transparent and fair review process that prevent both overblocking and discriminatory enforcement. Ultimately, law and technology for me are not enough. We must foster a culture of digital responsibility grounded in critical understanding of online dynamics, algorithmic amplification, and the social effect of our interaction. To conclude, I would like to emphasize that online hate speech is one of the most urgent and complex challenges of our time. We cannot just use criminal law to punish, and we cannot leave everything to algorithm. We need a system where different groups, institutions, platforms, civil society, and users cooperate. The Digital Services Act represents a significant step forward, but its success will depend on our ability to translate this ambitious legal framework into effective everyday practice. Our task is not only to curb hatred, but to preserve a digital environment that remains open, pluralistic, safe, and respectful of human dignity. Thank you for your attention.
Thank you, Lavinia. So our third speaker is Dr. Stephanie Reynolds from the University of Liverpool, and the title of her talk is Profiting from Hate or Participating in Debate, Critiquing Elon Musk's Unique Political Reach as Owner-User of X.
Thank you to the organisers and to Eliza for this morning. It's great to be here. So this is my topic. As we know, Elon Musk has used his X account to make increasingly populist interventions in British and wider European politics. But we also know that Musk is no ordinary X user. He owns the platform. He has over 200 million followers. I've put users following him. And he is the richest person in the world, and depending on the political wind, temperament, he is the on-off right-hand man of the US president. So consequently, I think that we can use him to explore the three themes of this conference. So as owner-user, he stands in a position of responsibility at the nexus of digital hate speech and hate crime. This gives him this ability to amplify populist messages, but we also need to look at his societal position and the reactions of established constitutional actors to his conduct, because this cements his position and it allows him to operate as a de facto populist leader. And so I think this throws into sharp focus something Eliza said in her keynote, which is that we need to look at the kind of broader societal issues as well as mere regulation. We need this multifaceted response. So what decisions has Musk made as ex-owner which have had an impact on hate speech? Well, we know he disbanded Twitter's Trust and Safety Council when he took over as CEO. He also, in the name of making X the online town hall, reinstated banned or suspended accounts. He reinstated the account, for instance, of Tommy Robinson, who is a former leader of the English Defence League, and self-proclaimed misogynist Andrew Tate. Both of these men then posted to X about illegal immigration in the immediate aftermath of the tragic killing of 3 children at a Taylor Swift-themed dance class in Southport in August 2024, which led to rioting. So Andrew Tate, for instance, although he later retracted the comment, reported that the attacker was an illegal immigrant and that people needed to wake up. The perpetrator had, in fact, been born in the UK and had been living in the Southport area since 2013. And Tommy Robinson, in a related issue at Manchester Airport, tweeted, "Get up there and show your support. People need to rise up. Our daughters are being butchered at dance classes. What's it going to take to unite the people of this country?" This received 634,000 views on X. But that really pales into significance compared to the amount of interaction his X post started to receive over the course of the riots themselves. So he posted about people revolting against what was happening and a video of a police station being destroyed in Sunderland. That actually turned out not to be a police station, but and said, "You should have listened, Keir Starmer." This received 5.4 million views on X. He reported a stabbing of protesters by Muslims. This was viewed 2.7 million times and was later reported by FullFact.org to be fake news. But as we know, fact-checking doesn't have the effect that we want it to. So we can question. Sorry, I'm not using the flicker properly. So we can question. The link, it's hard always to prove the link between online activity and real-life violence. It wasn't Tommy Robinson alone that was causing these protests. But we did hear protesters in Belfast, for instance, shouting his name during the rioting. And we can see an increase in his online activity during the protests. So how does this link to Musk's decision? Well, Musk reinstated him on the platform in the name of free speech, and we may well agree with that. He holds a blue tick on the platform. We know as well that Musk changed how the blue tick operated when he became owner. He linked it to a premium pay-for service, which is explicitly linked to post prioritization. Regardless, we also know that Tommy Robinson likes that. He posts his stats and how he's performing as an ex-premium user. Regardless of the blue tick, Amnesty International, around the time of the riots, found that X's content algorithms prioritize this type of content that spreads misinformation, and they allege that X's design choices significantly exacerbated human rights risks for racialized groups during these riots. The Centre for Countering Digital Hate has also argued that engagement with Robinson's X posts increased dramatically during the riots. They note he had about 11.1 million daily views beforehand and around 54.3 during them. So I think this adds some nuance to our echo chambers argument that we often hear discussed, because there appears to be a feedback loop between online activity and real life unrest. Robinson may or may not have stoked this unrest online. We see people on the streets chanting his name. We see further interaction with his online posts as a result. And then we see him posting more. So it becomes kind of this vicious circle. I'll remember to do this time, my apologies. Okay, so that is Musk's decision as owner. What about Musk's decision as user? Well, he has 200 million followers on X. This allows him to boost the narratives that he chooses, often by posting exclamation marks or one-word comments in order to give access to his followers to certain commentators. He did this with Robinson during the protests. So he put 2 exclamation marks above a post by Robinson that accused Keir Starmer of labelling people thugs during the protests for simply being concerned, and Musk responded with 2 exclamation marks, so giving access to those 200 million followers. He didn't limit himself, though, to this kind of boost. Oh, sorry, we also, as well as having those followers, there is reporting that X's algorithms prioritise Musk's content as well. He also began writing fuller comment himself, so when right-wing commentator Ashley St. Clair blamed the riots on mass migration and open borders, Musk said civil war is inevitable. This attracted press comment and got 10 million views on X. And when rioters began to be arrested, he posted 2-tier Keir, insinuating that tougher policing was predominantly against white protesters rather than Muslims, and this got 7.2 million views as well. And we see that Musk's UK interventions are not limited to the riots. We also saw him commenting on the decision of Jess Phillips, the UK safeguarding minister, not to have a national inquiry into grooming gangs in the UK. This is and should be open to scrutiny. That's fair enough. But he responded by calling her a rape genocide apologist, and this got 43.4 million views. And she commented anecdotally that she saw a link between this disinformation. She did support locally led inquiries, just not a national inquiry. She said this was disinformation that endangered her, and that there had been an increase in violent emails. And actually, we did see a conviction as a result of the email she received. So this is a headline: Devon man jailed for sending utterly deplorable email to Jess Phillips, MP. And the Crown Prosecution Service in the UK noted that the email sent by Jack Bennett to Jess Phillips came 1 day after Elon Musk's online post. And the judge in that case said that Jess Phillips was particularly concerned, mindful of the treatment, the increasingly hostile treatment of female MPs and the murder of her friend Jo Cox during the Brexit referendum. So that we can say that Musk could stand accused, even if we find it hard to demonstrate, of fueling the riots and endangering politicians as a result of his online activity. But I think that we shouldn't be looking at him as kind of this lone wolf rogue billionaire who's commenting online. We need to start thinking about his position and that of those like him within our constitutional ecosystems. We're thinking about reactions to him. We also need to think about drivers of his power. Yes, he enjoys extensive reach as the owner of Twitter, but this is further cemented or amplified by the reactions of established constitutional actors like politicians, like the media, as a result of his societal position. So his offline power is extending his online reach. He is not a normal person. So we can see this in the context of the grooming gang situation. So when Keir Starmer held a press conference on the Labour strategy for reducing NHS waiting lists, the press instead asked him about a online poll that Musk had posted asking whether America should liberate UK from the tyrannical government. Starmer refused to engage. And then the press instead asked him about Jess Phillips. Is Musk endangering Jess Phillips with these posts? And so in the end, Starmer responded in the way outlined on the slide. We also saw the Conservative opposition change their tune and get on the Musk bandwagon. So the Conservative opposition brought an amendment to a bill that was going through the UK Parliament to push this issue of a national-led inquiry into grooming gangs. Again, this may be an appropriate use of scrutiny of a government decision, but the way it came about is interesting. It would have had negative impact on the bill itself, which was about something different. It would have caused delays to the implementation of an existing inquiry into child sexual exploitation because it would have launched another inquiry. In the end, this amendment didn't get through, but the Labour government participated in a partial U-turn. As it says on the slide, the ministers utterly refuted Elon Musk's intervention as prompting this government action. But BBC analysts insisted there'd be no way it would have happened without Musk's intervention. So we're seeing a kind of cementing of his constitutional position, I think. And we see this also with the kind of comments, public comments by kind of Labour grandees. So when he was still being considered, he's now gone to be ambassador to Washington. Labour grandee Peter Mandelson had said that Musk is a sort of technological, he said this publicly, a technological, industrial and commercial phenomenon who it would be very unwise, in my view, for Britain to ignore. You've got to get over it. He's got to be reintroduced to the British government. Around this time, Musk was tweeting that the UK was a Stalinist state. So can the Online Safety Act help us? Probably not. So when the UK OSA was passed, it was touted as making the UK the safest place in the world to be online. And originally, it was envisaged as removing self-regulation from the platform. As Peter Coe has argued, though, the OSA actually reveals this paradoxical disconnection. It's been watered down in acceptance and acknowledgement of that tension that we've talked about already a lot today between free speech and online regulation. But Coe argues that this does so in a way that fails to recognise existing flaws in social media's realisation of the town square. The idea that algorithms and commercial drivers push misinformation, and we don't have that marketplace of ideas operating in the same way. As has already been discussed in Eliza's keynote, then there is an over-reliance in this legislation on social media platforms' vague terms and conditions, which Coe argues will worsen over-removal, because illegal content is broadly defined, we can use that to remove things, but there is latitude there for the owner user also to leave stuff up. And when it comes to legal but harmful content targeted at adults, considerable latitude is left to social media policies, but with an emphasis on consistency. But the policies themselves obviously leave latitude for certain choices. So if we look at the X rules, we also believe that criticism of institutions, practices and ideas is a fundamental part of the freedom of expression, and thus we will not take action on such critical commentary. Sounds good. But we also recognise that sometimes it may be in the public interest to allow people to view posts that would otherwise violate our policies. So the social media platform itself is defining public interest and it can give itself latitude in this way. We do see certain offences being introduced in the OSA. They have very high thresholds, which make it hard to use them in practice. We have Section 179 of the OSA, the false communications offence. This is, for reasons of free speech, targeted at disinformation and not misinformation. We have to have a knowledge of the falsity of the information and an intention to cause non-trivial harm to a likely audience. This is not going to apply to Musk anyway. Look at, are we going to arrest Elon Musk when he comes to the UK? No. But also, if we look at his tweets, they fall on that fine line that you were talking about in your keynote between hate speech, misinformation, and political speech, genuine scrutiny. So two-tier Kia, which we discussed, would not attract this. And we also, civil war is inevitable, would not attract this kind of offence. Section 181 of the OSA makes it an offence to send death threats or threats of serious harm. This is a high guilty act or actus reus requirement. Calling Jess Phillips a rape genocide apologist would not fall within this. And then we have Section 127(1) of the Communications Act 2003, which does make it an offence to send grossly offensive messages. So this could affect those kind of subsequent emails sent by users as a result of Elon Musk's targeting of Jess Phillips. But it's not priority illegal content, as far as I'm aware, for kind of removal under the OSA. And clearly Musk isn't scared. Since then, he has been digitally sent to protests in the UK organised by Tommy Robinson. He gave this lengthy and quite bizarre tweet about Tolkien, and we also know that we saw his reaction to the EU fine against him as well. Sorry, I forgot to do that. Okay, so this has led academics like Peter Coe to ask whether or not regulation can ever solve the problem. And he says, well, there's no silver bullet. And he talks about kind of what Lavinia was talking about as well, which is the need for proper funding of the online regulator, taking responsibility for our own online behaviour, improving digital education and building resilience. I think this is an important part of a multifaceted approach. It also requires trust in government. If we are having either government-led or even regulator-led initiatives on digital resilience, it requires trust. And we know that actors like Musk and the social media platforms are working to undermine that trust, so it makes it difficult. We can also look at wider constitutional responses within that kind of constitutional ecosystem, this idea of social accountability and the court of public opinion. We saw Tesla's market shares drop when he went to Doge. We saw departures from X by big kind of organisations and institutions during the riots. A YouGov poll actually said that British citizens thought he should be kind of butting out of our politics. We have seen traditional media is cementing his position by talking about him so much, but it is also responding. It's criticising him, and we are seeing the arrival of social media and misinformation correspondents within the traditional media to kind of fight back against misinformation and disinformation. We've seen the summoning of social media executives to select committees in the UK and a threat to summon Musk himself, although that's not happened. And a promotion of the media as a trusted voice. But once again, this requires kind of a consideration of the broader narrative in which democratic debate is taking place and social media itself. And Musk seems impervious to these sorts of constraints. Once again, we require trust. Okay, so I'm nearly finished. So we also, I think, need to look kind of not just at the responses, but at the drivers of this position. It's kind of like this circle of activity. So Kouliakis says that there is a striking yet neglected interplay between immense economic power and high politics. And Von Thun talks about the when it comes to extreme concentration of wealth and power in the hands of a small number of American oligarchs, the US government itself naturally bears most of the blame. By slashing taxes on high incomes and wealth, weakening labour unions and crippling competition, the US government has denuded itself as some of the most powerful tools for tackling plutocracy. And he talks about European importation of this neoliberal model as well. And we have to accept that Europe and the UK is leaving itself increasingly hamstrung. While Musk is behaving this way on Twitter, he is also providing public services. His Starlink provides internet connectivity, as Alamano and Veraldi highlight, to tens of thousands of Europeans. The UK is considering opening up its electricity market to Tesla, and Starlink and SpaceX, as we can see by the news article on the side, is central to Ukrainian war efforts. And so we need to think about kind of what the neoliberal model is doing in terms of hamstringing our governments, but also what liberal constitutionalism has done. Lachlan talks about this. He says constitutional democracies are not being overthrown but degraded. Populism works from within. It's caused by globalization, which has removed citizen participation from things that affect their lives. And we've preserved the market over democratic self-determination. We know that liberal constitutionalism, we saw this in Gavin's discussion of the US, that we have this enforcement of a public-private divide, and we see the private co-opting of this divide by people like Musk and Zuckerberg, this focus on the individual right of freedom of expression in order to cement their commercial and political position. Gavin's talked about the US free speech doctrine and about platform owners' rights to engage in content moderation, so I won't talk about that. Overall, then, I think even though Musk is in this unique position, when we look at him, we can also look at how ordinary users are being affected by these constitutional and economic drivers. As Lachlan says, that the interests of ordinary people are being ignored is not unfounded. Once again, the question is whether this development has been caused by the erosion of constitutional democracy or by its evolution. A regime captured by wealthy elites is not a constitutional democracy. It is at best an oligarchy, at worst a plutocracy. So ultimately then, it pays for billionaires to divert the attention of disempowered populations away from themselves towards other groups by drawing on the language of individual rights, by drawing on the language of freedom of expression and liberal constitutionalism. While social media echo chambers and internet conspiracies create false feelings of empowerment and community that aren't being felt in the real world. The real challenge then for modern states is not just to square this free speech circle through law, but also to restore citizen empowerment and strip hate speech of its seductive power. Thanks very much. I'm sorry I kept forgetting to link.
We have about 14 minutes for questions, so let's open it up, and we'll collect a few if that's all right with the speakers, and then they'll respond. So who would like to kick us off?
I'm just wondering what our experts think of the US administration's attack on the situation of freedom of expression in the EU. I mean, does he have a point, and why or why not?
Thanks. Next question. Yeah, in the white, gray. I don't have my glasses on. Or whatever. Yeah, you can work it out amongst yourselves. Okay.
I have two questions for the two first panels. Firstly, with regard to the 5 forms of regulation, of platform regulation. You mentioned these platforms often come from America, and now they are being confronted with all these different types of regulations. So you identified 5 forms of regulation, but do you see a very difference in how platforms behave in different jurisdictions? Or is there always kind of this awkward midway that they go, that they do follow the strict rules, but kind of try to find their own midway? And with regards to the second panel, I know it is a very difficult question, so if you don't have an answer yourself, don't worry, but if you have any sources on this. You mentioned the definition of online, of illegal contents, and I also know there's a lot of criticism on it that is too broad, and that we might need a new definition at EU level, but what could that definition be? Is there any sources available that help define this? Because I also find this very difficult to kind of grasp.
Thank you. I think we'll take at least one more question. Sorry, Juliana, you have the mic. So
Anyone else?
no, we'll come to you next. Yeah, go ahead.
Okay, so my question is for Gavin. Although I agree that from the 5 models that you identified, the DSA seems to be the best one, I wonder if it's the best one globally, or if we can think about other forms of models that work better locally, or should we just export the DSA on an overall Brussels effect?
Okay, thanks. And the person right here.
Yeah, I think I have more practical questions. I'm one of them affected from these issues. Online platforms have increasingly become spaces used by authoritarian regimes. They simply use their thousands of trolls to spread disinformation and hate speech. My question goes to Professor Phillipson. What are the mechanisms that individuals or groups can use to protect their rights? Is this difficult?
Free speech rights? Their free speech rights, or okay, thanks. So I'm just going to open it up to answering these to make sure we at least get through these, and then we'll go for another round. So Josh's question was first: is the Trump administration's attack on free speech in the EU? Does he have a point? I'm going to try to restrain myself on this one because I was not a presenter, but as an American, I do have a lot of opinions. But I'll open it up to the speakers if you have anything to say.
I mean, very quickly, I'd say yes. Yes, they do. It's very easy for Europeans just to be, see the hypocrisy in the Trump administration's attacking Europe on free speech while it's attacking at least the free speech of its non-citizens. Apparently, we're now going to have to give 5 months of our social media usage to be allowed in the US. But I do think there are problems, particularly with the case law of the European Court of Human Rights and its recent case law on hate speech. I think it's enforcing overbroad laws. I think the case of Sanchez in France is particularly problematic, and I don't think it's working. I think that people are reacting in the way that has often been predicted to overbroad hate speech laws. It's creating resentment. It's creating actually further support for far-right politicians who are sometimes being criminalised under these laws. And I think that we need to look for ways of reducing hate speech laws to the core things that we want it to do, and not just using it to catch, as it sometimes does. I think merely right-wing speech that a lot of people support, but that the government or judges find objectionable. So I think it is something we should think about. Yeah.
Yeah, I won't add to that except what's behind Trump's attack? I think there may be three things. And some legitimate, I think, and some maybe more strategic. First, we've talked about legal, cultural, the difference between US views on free speech and European views on free speech. This can just be kind of a genuine difference that he's hearing about, but I think that is being pushed by tech magnates who benefit from that. And we saw Zuckerberg come out as soon as Trump became president and changed the content moderation policies of Facebook. There are commercial drivers of this. We've seen Musk's reaction to the European Commission fine, again drawing on the language of free speech. So I think we've got genuine legal, cultural, then commercial, and then the commercial links in then to political and America first. So we heard in Gavin's presentation about the dominance of American tech firms. We've had a question about the Brussels effect, and there's a real tension there, and I think that's what is driving that. But I also think I agree with Gavin's point that there are genuine questions about European regulation as well. And I actually was asked by a journalist when Musk was tweeting again about the UK, what do you think we should do? And I said fewer billionaires, but that was not a tight enough answer for the journalist. So he said, no, do you think we should have more regulation? And in my view, more regulation feeds the far right, because it is exactly the narrative that Musk is using. Europe is attacking civilization, it's attacking free speech. If we regulate more, that just feeds that narrative. So it's a very, very difficult problem to solve. Pass the mic on. Yeah.
I want only to say that freedom of expression is very different in USA from Europe, because in Europe, freedom of expression is balanced with other rights. In America, it doesn't work like this, because it's in the Second Amendment and it's very like a super right. So it's very different to like really truly understand the culture, freedom of expression in USA from European people, because it's very different. Also the mechanism, also the platform, also the mentality of the people from Europe to USA. This is my opinion, actually.
Okay, in the interest of time, I'm going to restrain myself, but if anyone wants to ask me later about how I feel about that, I'd be happy to let them know. All right, so the next question related to the 5 forms of regulation.
Yeah, I think the question was about do platforms behave differently in different jurisdictions. So I think it's a little bit early to tell. We know already. So Meta, in its announcement in the beginning of 2025, said it was ceasing fact-checking on only on the US versions of its platforms, not on the European ones. It may be that actually things like the DSA and the UK's Online Safety Act make relatively little difference to what is removed. So the one major study we have of Germany's NetzDG law, which was the first of these laws really, by Claudia Haupt, found that actually the vast majority of removals, the stuff would have been removed anyway under their community standards, because the community standards tend to go further even than European hate speech laws often, which actually makes something of an irony of the US criticism. But obviously that depends at any given point what the community standards are. If the community standards become more permissive, then European hate speech laws will start to bite more and demand more content removal. And at that point, I think only at that point will we see how the dynamics emerge of platforms operating in different jurisdictions and how much difference it actually makes to them.
Then the next question was about online harm that was directed to Lavinia. Okay, and whoever else would like to weigh in.
Thank you for your question. The problem is that the DSA, in the Article 3, don't indicate what constitutes an illegal content precisely. So I don't know actually what could be the definition, but for me must be universal for every state in Europe. So illegal content is something, and is like for Italian people, for Belgian people, for UK people, for everyone.
What's the next one? Okay, and then we're back to you.
Was this about should we just export the DSA? Well, I think we should see how it works out first. I don't want European imperial regulation. It may be that other countries have particular problems that the DSA wouldn't cover. There is the issue of the fact, I mean, for example, the Online Safety Act actually has a long list of criminal provisions that are covered, which is quite a sharp contrast to the European one of just defining it as illegal content. So it may be that I think we need to wait and see for a while how these different regulatory schemes work out, because I think there's a lot of unknowns there. In particular, the soft powers that the Commission has in relation to things like disinformation, threatening electoral integrity and health. I think it remains to be seen how those are going to be exercised. And similarly, in the UK, Ofcom has a great deal of discretion and powers in the way that it regulates under these things. So I think before enthusiastically telling the rest of the world to adopt them, we should give them a few years to see how they actually work, how efficacious they are, and in relation to the other question, how much they actually affect platform behaviour, which may turn out to be not that much. We may need to rethink quite quickly as these technologies are changing so quickly. So I wouldn't be an enthusiast for just DSA everywhere.
Okay, and then the last question was about protecting users' rights.
I mean, if you're European, you have some rights, which is nice against platforms in relation to, you have due process rights, you have quite, even under TERIG, which I'm very critical of, because I think that its definition of removable content is far too broad and could catch a lot of edgy, marginalised voices and unpopular points of view. But at least you do have quite strong due process rights. In the US, you have nothing but what the platforms condescend to give you. And Twitter, in particular, has a famous clause that someone described as Schmittian, where it says that we can remove your content for breaching our community standards, or for any reason, or indeed no reason at all, which is what the Canadian lawyer who's bringing in the case against Twitter in Canada described as a Schmittian clause in it. So I think Europeans need to make use, and actually that's another thing. How well will these due process rights that DSA and other instruments give us actually work out in practice? And if they don't work very well, then we need to strengthen them. But for now, I think we should start using these relatively new rights and be grateful that we're Europeans.
I agree with that. Okay, we have 2 minutes, so I'm not sure that leaves us with time for another question, or we can just sort of wrap up. I just have to comment on the Trump question, though. I think it's, well, when they were alluded to it, but just absolutely audacious and outrageous for the way that the Trump administration is behaving in the United States in terms of completely antithetical to every First Amendment principle. And then to come to Europe and lecture Europeans on, free speech is just, and I think it's part of the broader attack on Europe, really, right? As part of this sort of broader, attack on our allies, right, to consolidate even more power. And I'll stop there. But I had to get that out. All right, well, thank you to our speakers and to our wonderful questions, and let's give everyone a round of applause. All right.